oppose our tougher immigration legislation. Enough is enough. The opposition have delayed this bill for too long. We must get on with it. So, Mr. Speaker, of course I give way to the Honourable.
I'm sure the Minister will, like me, have read the Law Society of England and Wales briefing on these amendments. Has he seen polling reported by them which show that the majority of voters think the government should either accept some amendments to the Rwanda policy or scrap it altogether? Only a quarter of the public think the government should try to get the Rwanda bill through in its current form, and all Lord's amendments are supported by the majority of the public. Has he seen that polling, and will he therefore stop trying to turn this into a political football and address the gravamen of the amendments?
I certainly will. I'm very grateful indeed to the Honourable and Learned Lady, because she gets to the point of the amendments themselves. She's absolutely right that we should address them in detail, and I will do just that. But before I do so, I give way to the Honourable Gentleman.
Mr. Speaker, I say this with all humility and also with respect for the Minister, who I know is an honourable person. But does the Minister not agree that there's a simple way out of this deadlock? And that is to accept that those who can demonstrate that they were assisting the British forces in Afghanistan. And does the Minister not further agree that this back and forth is not an example of democratic exercise, but rather that of democratic embarrassment? And a way forward must be found before we bring this place and our procedures into disrepute.
Minister.
Well, I'm very grateful indeed to the Honourable Gentleman. As always, he engages with the substance of the matter. He and his right honourable friend, the member for East Antrim, have raised this point. I'm going to turn to that specific amendment second, and I hope to seek to persuade him by my words that there are steps that have been taken, there are reassurances that have been made, and I hope to reassure him personally that he will be able to support the government in the division lobbies later on today. Mr. Speaker, turning to the Lord's amendment from the noble Lord, Lord Hope of Craighead. I just want to reiterate firstly some salient points. Firstly, as this House knows, we will only ratify the treaty once we agree with Rwanda that all necessary implementation is in place for both countries to comply with the obligations under the treaty. Secondly, the implementation of these provisions will be kept under review, as we know, by the Independent Monitoring Committee. Thirdly, Clause 9 of the bill makes clear that the bill provisions come into force when the treaty enters into force. Mr. Speaker, I respectfully
coming into force.
Of course I can.
I know that there's a problem in detaining migrants, illegal migrants at the moment under habeas corpus, but when the bill comes into force, is the legal position that we can then detain people before offshoring them, because that's the only real deterrent?
Minister.
Well, my right honourable friend may have heard a few words from the Prime Minister in this regard this morning, and that is exactly right. Specifically, in relation to this amendment, however, I respectfully disagree with the noble Lord, Lord Hope. There is no obligation, whether in legislation or in the treaty, to send anyone to Rwanda. As my noble friend Lord Sharp has said, Article 4 of the treaty sets out clearly that it's for the United Kingdom to determine the timing of a request for relocation of individuals under the terms of the agreement and the number of such requests made. Of course I give way.
Extremely grateful to my right honourable and learned friend, and before he moves away from the treaty, I wonder if he could help with some clarity on the relationship, as the government sees it, between the Rwanda Treaty on the one hand and this bill on the other. Specifically, is it the case that an assessment of Rwanda's safety for the purposes of this bill is the same thing as compliance with the Rwanda Treaty on the part of the state of Rwanda? And if not, what is the difference? Does the concept of safety extend beyond compliance with the treaty, or is it solely limited to the question of compliance with the treaty?
Well, as ever, I'm very grateful to my right honourable and learned friend for his engagement both inside and outside the chamber. He's been a regular attender, and Mr. Speaker, as you know, to these ping-pong sessions. In terms of the treaty itself, the treaty is the operating legal instrument between two international bodies, between the United Kingdom and between Rwanda. That is the status of that treaty. This bill brings it into effect in law in this country. And he knows, dealing with the system of dualism, in fact, he's appeared in the Supreme Court arguing these very points himself. So he knows in detail the differences between the treaty and between an Act of Parliament. As I set out within the treaty itself, there is no obligation. It's there, it's plain, it's written, as he knows, in Article 4.1, that the United Kingdom shall not be obliged to make any request for relocation under this agreement. I will do in one moment, and that means that the government would not be obliged to relocate individuals under the terms of the treaty if there had been, for example, unexpected changes of circumstances. And I know that's something that my right honourable friend and learned friend has been concerned about. I give way.
Supporting this exchange, would my honourable friend also care to note that Lord Hoffman, in the case of R versus Lyons, was quite unequivocal when he said that and this was in relation to an ECHR case as well, that the treaty itself is not the same as the statute, in that it is the statute that prevails, and when the statute is made and the words are clear and unambiguous, it follows that the court will obey what the Act itself sets out, which is absolutely exactly what the position is in this case.
And Mr. Speaker, my honourable friend has also been a consistent member of these ping-pong sessions, and he has consistently cited that passage. That's paragraph 144 from the Supreme Court judgment, and he knows that I agree with him on this point, and that I firmly believe that this legislation as drafted is clear and is unambiguous, and I hope that reassures him on that point. But again, turning back to my right honourable and learned friend, there are procedures already in place under the terms of the treaty to monitor the safety of Rwanda for those who are relocated there. And I can reassure my right honourable and learned friend and this House that we have already established the right mechanisms so that should the situation ever arise, the government will respond as necessary. And this would include a range of options to respond, including, as my right honourable learned friend knows, any primary legislation if required. But, Mr. Speaker, implementation continues, and I can now confirm that last Friday, the Rwandan Parliament passed their domestic legislation to implement their new asylum system. The partnership is one important component of a much broader bilateral relationship. As my right honourable friend, the member for Witham, has recently reminded us, this is a migration and economic development partnership. And I'd like to put on record my thanks to all officials, including those in the government of Rwanda, for their hard work in implementing the treaty and delivering this crucial partnership. I give way.
I'm most grateful to the Minister for giving way. If Rwanda is truly safe, and I note what he said about last Friday, why is it the case that Rwandans are excluded from this legislation from being returned? And could he give us the reasons wherefore why the Prime Minister and himself refused to accept the need to prove the safety of Rwanda as a requirement?
Well said.
Minister.
The proof of the safety is in the international binding treaty between two international partners, namely the United Kingdom and the government of Rwanda. And it is here in the treaty where it matches the concerns as set out by the Supreme Court, namely the concerns in and around refoulement. It is there, it is addressed in the treaty. That is the reassurance that I invite this House to take, and that is why I say that the amendments are unnecessary. Turning specifically, Mr. Speaker, to the second amendment, I will give way to my honourable friend.
I thank the Minister for giving way. The very obvious point about why Rwandans aren't covered by this is if we were returning a Rwandan to Rwanda, we would take them to their home country, not a third country.
Minister.
Well, again, I'm very grateful to my honourable friend because he has been closely following these proceedings, not just throughout ping pong, but throughout his time as well, when he held this role, and he knows deeply the interplay in the interrelationship between the two countries, and I'm very grateful to him. I'm going to make some progress, actually. I've given way too much. I've taken some criticism for the number of times that I've given way, and so I'm going to make progress, Mr. Speaker. So the Second Amendment. Speaking to the Amendment 10F, As I and my noble friend Lord Sharp have said previously, this government greatly values the contribution of those who have supported us and our armed forces overseas. And that is why there are legal routes for them to come here to the United Kingdom. And there is already existing legislation, Mr. Speaker, including but not limited to the Illegal Migration Act, which the Secretary of State has a range of powers to consider cases and specific categories of persons. I have already made a clear commitment on behalf of His Majesty's Government that we will consider how removal under existing immigration legislation would apply. And that means that once this review of Arab decisions for those with credible links to Afghan specialist units has concluded, the government will not remove to Rwanda those who received a positive eligibility decision as a result of this review where they are already in the United Kingdom. Just wait 1 minute, please. As of today. This is an important point, and it's a point that I emphasise today in front of this House. Yes, I give way to them, please.
I thank the Minister for giving way. He may have read about my constituent today in The Guardian. A man who was originally Afghan, has British citizenship, served with our armed forces for 15 years. He and his family were called forward to the Barron Court Hotel, could not get there because there was an explosion, and have been in hell ever since. His young children and wife unable to join him here in the UK. He's not eligible for ARAP because he was a British citizen. The government has written to me suggesting that his children might apply to ARAP. I believe under 10-year-olds probably won't qualify. The ACRS scheme is in tatters, will not accept them, because the government is now trying to say, well, they were invited rather than instructed to go to the Barron Court Hotel. If he takes 5 minutes just to read the story of my constituent who gave so much of his life to support our forces in Afghanistan, he will understand why, when he stands at that dispatch box and says that there are legal, safe routes for those who are eminently eligible, it is simply not sustainable as an argument to make, and why this amendment matters.
Well, this amendment is unnecessary. There is already existing legislation, as I have told the Honourable Lady, and I've tried to explain to this House, there is already existing legislation, including but not limited to the Illegal Migration Act. And I have confirmed that the government will not remove to Rwanda those who receive a positive eligibility decision as a result of this review. Mr. Speaker, this government recognises the commitment and responsibility that comes with combat veterans, whether our own or those who have shown courage and served alongside us. We will not let them down. Criminal gangs are determining who comes to the United Kingdom as vulnerable people are being lured into unseaworthy boats and risking their lives. Billions of pounds of taxpayers' money is being spent on illegal migration. Our resources and services are reaching their limits. We must put an end to it. We must pass this legislation and stop the boats. I urge this House once again to send an unambiguous message to the other place. The time has come for the Labour Lords to respect the views of this House and to let this bill now pass.
The question is, this House disagrees with Lords in their Amendment 3G. I now call Shadow Minister Stephen Kinnett.
Thank you very much indeed, Mr. Speaker. Well, there's not really a huge amount more to be said about this sham, this con of a bill that hasn't already been said. The plan is as unworkable as it is unaffordable, and that's why Labour would instead repurpose the money that's being squandered and set aside for the scheme into a cross-border police unit and security partnership which would go after the criminal gangs upstream and restore order to our border. And we would create a new returns and enforcement unit to remove people from the country who have no right to be here, given that we have seen the return of failed asylum seekers collapsing by 44% under the Conservatives and the removal of foreign criminals decreased by 27%. Our plan will end the Tory boats chaos, fix our broken asylum system and restore our border security. The government's plan is, as the former immigration Minister himself described it, and a civil servant insider has admitted, it's to get a few symbolic flights off the ground ahead of a general election, regardless of the wider impact. It really is tokenism and posturing of the worst sort.
I thank my honourable friend for making way on that and highlighting why this is just such a gimmick Does he agree that when the Permanent Secretary said that there is no evidence it will work as a deterrent, and this plan will only account for just 1% of those crossing the Channel?
Well, she's absolutely right that the test of a policy like this is, will it work as a deterrent? But when you're dealing with people who have risked life and limb to cross continents, they are not going to be put off by a 1% chance of being sent to Rwanda. So the policy fails on its own terms, and the Permanent Secretary was absolutely right to put that red flag on it 2 years ago. It's quite extraordinary that we are where we are today. I will give way.
I'm grateful to my honourable friend for giving way, and he's making an excellent speech. He spoke about tokenism of the worst sort. Does he agree with me that that was carried on by the Prime Minister's announcement, identifying 25 courtrooms and 150 judges will be available to deal with legal challenges from asylum seekers, giving our courts are struggling with backlogs, partly due to not enough barristers in courts. Exactly. So it would be interesting to know how the government would achieve this. Would my honourable friend agree with me?
Oh, she's absolutely right. I'd actually forgotten about that sort of chapter 562 in this never-ending story. And my recollection is that the Prime Minister was then slapped down, I think, by the judiciary, who said, well, we've got a huge amount of a backlog to get through, and this is not a priority. So I think we should thank my honourable friend for reminding the House of yet another sort of disastrous chapter in this story. I will give way.
In the unlikely event of a Labour government, is the Shadow Minister happy with the idea that in future the opposition parties that necessarily and usually dominate the House of Lords should frustrate a Labour government? So will he advise his friends up there to respect the will of the elected House?
I will advise the other place to do what it is doing as a revising chamber, standing up for the constitutional obligations that it has, to look at every piece of legislation that we send to them from this place, and to take the measures that they feel strongly about. What we are seeing is a set of amendments which in no way prevents this policy from being enacted, in no way prevents flights from taking off. It is simply those members of the other place doing their constitutional duty. But it's not only that the plan is completely unworkable, Mr. Speaker, it is also shockingly unaffordable. It is likely to cost a truly astonishing £2 million per deportee. And to add insult to injury, it puts the tens of thousands of asylum seekers who are deemed inadmissible and yet cannot be sent to Rwanda because of the lack of capacity there. They will be put into limbo in expensive hotels, stuck in a perma backlog at staggering cost to the taxpayer. Dreadful policy, shameful politics. Mr. Speaker, when this bill was first introduced, the Prime Minister described it as emergency legislation, and yet the government's management of the parliamentary timetable would suggest that the opposite is the case. Ministers had ample opportunity to schedule debates and votes on the 25th and 26th of March before Easter recess, but they chose not to do so. And indeed, last week there was also plenty of scope to accelerate this process. So you could be forgiven for concluding that the truth of the matter is that ministers have been deliberately stringing this out for two reasons. Firstly, because they thought that they could make some grubby political capital from the delay. And secondly, because they've been scrambling to get a flight organised and all the other logistics that are not in place. Indeed, the Prime Minister admitted this in his somewhat whinging and buck-passing press conference this morning, that the first flight to Rwanda won't take off until, checks notes, July. I mean, July, really. Today is the 22nd of April. We were initially told that this was emergency legislation, and yet we're now being told that there'll be a 10 to 12-week delay in getting the first flight off the ground. Madam Deputy Speaker, I don't know about what your definition of an emergency is, but a 10 to 12-week response time does seem to be a bit of a stretch. And of course, given that none of the amendments to the bill could by any stretch of the imagination be seen as wrecking amendments, it really is quite difficult to see why the benches opposite couldn't just accept them and get on with it. Because the fundamental point is that not one of the amendments that have been coming to us from the other place would prevent planes from getting into the air. Turning first to the amendment in the name of the noble Lord Hope. Well, this amendment simply reflects what the government has already said. that court judgments are taken at a moment in time, and that a country may well be safe at a given point, but not at another. And that, if this bill passes unamended, then this House will, in essence, be asserting that Rwanda will be a safe country forevermore. But, Madam Deputy Speaker, surely the indisputable lesson of recent times is that we live in a dangerous and turbulent world, where authoritarians are on the march and the rules-based order is under threat. So who knows what might happen in Rwanda in the future, or in any other country for that matter?
I'm very grateful to the Honourable Gentleman. And he will agree with me that, again, the Minister today made the point that just because we've entered into a treaty and we've been told it's safe, that suddenly should be treated as the way forward. Surely that's setting a very serious and dangerous precedent for the future, that we can work our way out of any unsafe country just because we have a treaty with them.
I agree absolutely with my honourable friend, and I thank him for that intervention. I think one of the reasons that we are seeing such a strong pushback from the other place is precisely because they are deeply uncomfortable with trying to make something that is not true. The Supreme Court has ruled unanimously that Rwanda is not a safe country, and yet we are being asked to legislate to say that it is. Now we can legislate to say that the sky is green and the grass is blue, but that does not make it so, and that is why we have such an important point of principle in this bill.
I thank my honourable friend.
Just before the Honourable Lady makes another intervention, I must draw to the attention of the House that we only have till 5:15 to debate this matter. I have 8 people on the back benches who wish to speak. Their speeches at the moment will be limited to 3 minutes, and it might not be entirely fair for the Honourable Lady to keep meeting. No, but please, Mr. Kinnock.
Thank you, Deputy Speaker.
Courtesy. Mr. Kinnock.
Thank you, Madam Deputy Speaker. Thank you. Therefore, the amendment in the name of the Noble Lord Hope simply requires the Home Secretary to lay a statement before Parliament confirming that the Rwanda Treaty has been implemented and that the country is safe. And prior to issuing his statement, the Home Secretary would presumably be taking account of advice provided by the government's hand-picked monitoring committee as specified in the treaty. And of course, Lord Hope's amendment also allows the Home Secretary to lay a statement making clear that Rwanda is no longer safe should the situation on the ground in Rwanda change. This trust but verify approach is embedded in countless pieces of legislation that have made their way onto the statute book over the centuries. It is a perfectly fair, measured, reasonable and non-controversial proposal, and frankly it's simply bizarre and incomprehensible that the government is refusing to accept it. Turning now to the amendment in the name of the Noble Lord Brown, frankly, I just don't know where to start with this one, Madam Deputy Speaker. It beggars belief that the government is still insisting on being able to deport Afghans who have bravely fought alongside British forces against the Taliban to Rwanda. It really is shameful that we are still debating what should be a given. We owe a debt of gratitude to the Afghans who stood shoulder to shoulder with our troops, and yet this government is seeking to trash our reputation as a country that honours its debts. What a disgrace. Ministers should hang their heads in shame. Now, over the course of the last few weeks, they've deployed a variety of spurious and mealy-mouthed arguments to defend their position. But the one they have most frequently used is that there are already safe and legal routes in place in the shape of the ARAP and ACRS schemes. But this is simply not the case, Madam Deputy Speaker. Operation Warm Welcome became Operation Cold Shoulder when the Prime Minister torpedoed both schemes and left these Afghans stranded. Shocking but true. Court documents show that in November 2022, the Prime Minister issued instructions to halt flights from neighbouring Pakistan for an entire year for Afghans who had already been granted resettlement rights in the UK, and only restarted them when the Pakistani government threatened to send these heroic individuals back across the border to meet their fate at the hands of the Taliban. Just let the content of those court documents sink in, Madam Deputy Speaker. The Prime Minister of the United Kingdom explicitly instructed the Ministry of Defence and the Home Office to stop assisting Afghans who had put their lives on the line for our country. What a disgrace. What a betrayal of British values. What a hammer blow to our moral standing in the world. But the noble Lord Brown's amendment is not only driven by a basic moral imperative, Madam Deputy Speaker, it is also driven by our national interest and by military logic, for the simple and obvious reason that the ability of our armed forces to recruit local allies to support us in the future will be severely constrained if this bill passes unamended. It should therefore not come as a surprise to anyone that our armed forces are outraged and repelled by the government's refusal to accept Lord Brown's amendment. Indeed, just last weekend, 13 senior military figures signed a letter to the Sunday Telegraph stating robustly that any brave men and women, and I quote, who have fought alongside our armed forces or served the UK government overseas must be exempt from removal to Rwanda. Madam Deputy Speaker, I therefore urge all those across the House to join with me in supporting these two amendments that are in front of us today. This whole process has been a farce. But if we can just pass these amendments, we can at least send a message that we are not a country that chooses to deport its military allies to a country on the other side of the world, and that we are a country that cares about whether or not we are sending some of the most vulnerable people on the planet to a place which is safe for them. At the very least, we owe that basic level of respect and decency to ourselves as a nation and to the people that this policy will affect. Unfortunately, respect and decency for anyone, whether it's in relation to our nation, to asylum seekers, or indeed to the British taxpayer, is not something that this Prime Minister and his government hold in any regard whatsoever. And that is why their time is up. They are not fit to govern. And I fear tonight that they will demonstrate that point in spades yet again. Thank you, Madam Deputy Speaker.
As I've just intimated, there will be an immediate time limit on backbench speeches of 3 minutes. Sir Jeremy Wright.
Thank you very much, Madam Deputy Speaker. In view of the time, I want to focus what I say on the second part of Amendment 3G, subclause 8. And I think it is clear that Lord Hope has drawn attention to a flaw in the bill's logic. We all understand it's about parliamentary sovereignty, but if declaring Rwanda safe in the first instance is a matter for Parliament, then why is determining whether it remains safe not also a matter for Parliament? And yet this bill covers only the first determination of safety and provides no mechanism for Parliament to change its mind if circumstances change, save for primary legislation, which of course it would need government to introduce. Now, Madam Deputy Speaker, my quarrel with the noble Lord Hope's amendments has been that whereas the theme of this bill is parliamentary authority, the earlier forms of his amendments give effective authority on the safety of Rwanda to the monitoring committee, because their conclusion on treaty compliance would be determinative of the question of safety. But the later versions of his amendments have transferred authority to ministers to determine, on the advice presumably of the monitoring committee, that Rwanda is no longer safe and make a statement to that effect. And I have to say, I think that is not perfect either. I still think that for the bill to have inherent and logical consistency, it should be Parliament's decision on whether Rwanda remains safe in changed circumstances, not a monitoring committee's and not a minister's. But how much latitude Parliament would have in deciding whether Rwanda remains safe in changes of circumstances rather depends on the point I raised in intervention with my right honourable and learned friend. If adherence to the treaty is evidence contributing to an assessment of whether Rwanda remains safe, but is not wholly determinative of the question of safety, then it remains possible, if unlikely, that Parliament would consider non-compliance, but nonetheless decide that Rwanda remains safe for the purposes of the bill. But if its only consideration on safety is the question of compliance with the treaty, then Rwanda cannot remain safe if it is in breach of the treaty. And I think, Madam Deputy Speaker, we need to be clear which of the two it is. But either way, determinative or not, if Parliament is to be the sovereign decision maker, it must know of non-adherence to the treaty. And directly or indirectly, the monitoring committee is the body which can tell us. So it seems to me we must look at Amendment 3G in the light of the late stage in proceedings we are at. We cannot keep batting this bill backwards and forwards across the building. And as I've said, I do not think this amendment is the best way to solve the problem. that Parliament has no mechanism available to it to change its mind if the facts change. But I have to say, with all due respect to the Minister for whom I have high regard, the government hasn't come up with a better alternative. In those circumstances, he leaves me little place to go other than to support this amendment if my right honourable friend can't propose a better way of resolving this deficiency.
Thank you, Madam Deputy Speaker. Well, the Minister opened by saying that he had looked forward last week to not debating this bill. Well, I wish indeed that the bill had never been brought to this House in the first place and that we wouldn't have to debate this bill. I wish that it had never seen the light of day. And if he never wanted to debate it again, he could have, of course, accepted the Lord's amendments last week instead of stringing this out for even longer, because these are perfectly legitimate amendments that the Lords had brought. But I see that the members on the benches opposite are seeking to get around the tedium of voting on amendments to render vulnerable people overseas. There's a text message circulating on X in the name of the Government Chief Whip saying, "Dear colleagues, with a potentially long and historic night ahead on behalf of the Prime Minister, I would like to invite you to drinks this evening from 9:30. These will take place in the Prime Minister's office in the House of Commons. I look forward to seeing you there." How absolutely heartless and despicable that the members in the opposite benches are quaffing drinks while they're thinking about sending people to Rwanda. How utterly without any kind of moral background whatsoever. And should the Lords send back further amendments tonight, should they carry out the procedural, unusual procedural matter of double insistence, I would certainly support them very much in that endeavour. Any mechanism that we can use in this place to stop this bill is what we should do. I will.
I thank the Honourable Friend for giving way, and I congratulate her on using every procedure that is available to her to state the SNP's opposition, not least, Madam Deputy Speaker, by moving amendments in the Reasons Committee last week, because we in the SNP will take every single opportunity to express our opposition to this outrageous plan.
I thank him for his intervention and would note on the record that Labour did not vote on any of the reasons that I sought to amend in the Reasons Committee, and I've yet to have any explanation as to why they wouldn't use any mechanism available to them to oppose this bill. And, Madam Deputy Speaker, we had yet another press conference this afternoon where the Prime Minister didn't come to this House to talk about his gurning and his greeting that those mean old Lords wouldn't let him have his way. And I would point out that the Conservatives have over 100 more Lords than Labour, and perhaps the lack of enthusiasm from their own Lords is reflective of the fact that many of them didn't even show up to vote last week. Because this is not in the Conservative Party manifesto. They have no mandate for the Rwanda plan whatsoever. And indeed, what manifesto would they put in front of people which would say we're going to set out to breach our international commitments and engage in state-sponsored people trafficking? What manifesto indeed would that be? And just to mention very briefly, Madam Deputy Speaker, some of the things that the Prime Minister mentioned in his statement, suddenly conjuring up a whole load of judges to determine these cases, when they could be better served, perhaps, looking at the appeals backlog that his incompetent bulk processing of asylum claims has created. He mentioned charter flights being booked. Well, many commercial companies had refused to be involved in the charter flights at all, including the Rwandan state carrier. So which companies have been engaged to do this, and at which cost? We still don't know. He said that the first flight will leave in 10 to 12 weeks. Will this be before or after we reach summer recess? Because we know already how far the timescale has slipped for the government on this, and what scrutiny will occur should these flights take off during recess. Madam Deputy Speaker, if they do indeed manage to send anybody to Rwanda, where are they going to put them? Because we know that the Rwandans have sold off the housing that they set up to place people in. Will they be piling them up in tents? I wouldn't put it past this government, but it would be useful to know. Moving to the Lords' amendments themselves, Madam Deputy Speaker, we fully support these Lords' amendments, which do their very best to mitigate an absolutely dreadful piece of legislation. And I cannot see what the government's objection really ought to be in Amendment 3G. They were all about taking back control, but yet there were absolutely no parliamentary scrutiny whatsoever of whether Rwanda remains a safe country. And the honourable member from Kenilworth and Southam quite rightly pointed out, we have no means in this place of declaring Rwanda unsafe. We say it's safe for in perpetuity, forever and ever and ever. We can't declare it unsafe should something happen. That is just not logical. And I would note also that the Irish High Court ruled last month that the UK, in fact, is not a safe country to send asylum seekers to in light of these plans. I fully support also the new Amendment 10F from the Lords regarding Afghans. And I've mentioned it many times before, my support for those Afghans who served and supported UK objectives in Afghanistan, and how woeful the government's response to the need of those people has been. And I would point... I will briefly, yes.
I'm grateful to her for giving way. Would she agree with me that rather than spending £11,000 per person to deport them to Rwanda, that money could be used right now to rescue my constituent and his wife who got out of Afghanistan into Pakistan and are now stuck there waiting for the UK government to rescue them?
I wholeheartedly agree, and I know of many such cases of people who have been sorely let down by this government. And we note that the figures that the government brought out this morning, that there has been an increase in small boat arrivals this past 3 months compared to last year. So it's hardly any kind of deterrent if people are still coming over in small boats in their droves. But I would note amongst them were 1,216 Afghans, an increase on the 1,098 that came in the same period last year. If he thinks the Afghan schemes are such a roaring success, why are so many Afghans being forced onto small boats just to get to safety? Many of them will have family in this country. Many of them will not have been able to avail themselves of the Afghan schemes he so talks up. And many of them will not have been able to use family reunion, which is an existing safe and legal route which many people are not able to access. Madam Deputy Speaker, in light of time, I will not go further into the detail of some of the Afghan cases I wished to raise. But I will say this to this government. This legislation is utterly despicable. It is state-sponsored people trafficking. It is against our obligations in international law, and Scotland wants no part of it. We will oppose it every step of the way.
Tim Lawton. Speaker, can I start by agreeing with the opposition spokesman when he said that there's nothing new to say? The trouble is that he then spent 14 minutes saying nothing new. And to say that these amendments do nothing to stop flights getting off the ground. The fact that we are still having to debate amendments is preventing the legislation going through which would allow the scheme literally to get off the ground. So now it's time to get the Rwanda legislation done. The remaining amendments, many people have had days, weeks and months to make their points. The government have given undertakings. We've heard further undertakings about the treatment of Afghan refugees here today. This bill does not oblige the government to return anybody from Afghan. There are explicit schemes particularly to protect them. And in terms of declaring Rwanda a safe country, the only reason the legislation has stated such is because a court declared it not to be based on limited and snapshot evidence. The government has a white list of countries which are not deemed to be safe. The FCDO issues guidance about where it's safe to travel. But what does constitute safe in the eyes of those courts? Is Spain safe if you're a Catalonian dissident who is in exile because they've taken issue with the Spanish government? Is it safe to go back to France? Some of the refugees I've met in the Napier barracks claim that they are beaten by French police and it's not safe for them to go back to France. Indeed, is London safe if you are openly Jewish in the eyes of some court judgments? There are plenty of safeguards that are given in this bill. It will bring people back to the UK if it's deemed not to be safe or appropriate. There's plenty of international legal scrutiny now added into this bill. The issue of refoulement, which was the major complaint about by the Supreme Court, has been dealt with. Legal assistance is available for those sent to Rwanda. And we know, and I'll say it again, when the Home Affairs Select Committee went to Calais last year, we were told by all of those in charge of the policing system on the beaches that when the government announced the Rwanda scheme in the previous May, there was a surge in migrants around Calais approaching the French authorities to try and regularise their position in France because they did not want to risk being sent to Rwanda. What is disgraceful, Madam Deputy Speaker, is time and time again those behind these amendments, the Labour Party continuing this ping-pong, have not come up with a single solution to the really important question of what do you do with asylum seekers who have come to this country illegally, who have no credible case to be in the UK, but for whom it is practically impossible to return them to this country. And what's also absolutely disgraceful is just this morning the Shadow Home Secretary has made it quite clear that a Labour government would abolish the Rwanda scheme, whether it's working or not. What they are saying to people the other side of the channel, just wait a few months, then you can come in your droves as much as you like. That is the truth of the matter. These amendments need to be beaten again.
Dame Diana Johnson.
Deputy Speaker, and whilst I agree with quite a lot of what the Honourable Gentleman says at times, that point that the Honourable Gentleman just made about Labour's policy is absolutely incorrect. Can I just say that I'm very pleased that the Minister has stated at the beginning of his remarks that the other place has absolutely the right to act as a revising chamber and to give their advice to this chamber. Lord's Amendment 3G is tabled by the noble Lord Hope of Craighead, as we know, a former Deputy President of the Supreme Court, and it states that Rwanda cannot be considered a safe country for the purposes of the Act until the Secretary of State has obtained and laid before Parliament a statement from the Independent Monitoring Committee confirming the treaty provisions have been implemented. And it also allows for the Secretary of State to rescind the confirmation if the treaty stops being adhered to, rather than the nonsense position of claiming that Rwanda is safe forevermore. This is a sensible and measured amendment to deal with the facts and for allowing them to, when they change. And on the day that the Prime Minister has stated that some asylum decision makers and judges have been trained, the Joint Monitoring Committee set up and the President of the new appeal body selected, we still don't know whether all the other provisions of the treaty have been fully implemented or whether the number of officials in place is sufficient. So with the Prime Minister insisting that flights will begin in 10 to 12 weeks, Lord's Amendment 3G provides a vital safeguard ensuring everyone sent to Rwanda will be protected by the implementation of the treaty provisions. And I think this is entirely reasonable, and I agree with what the Right Honourable Member for Kenilworth and Southam said. Just turning to Lord's Amendment 10F, tabled by the noble Lord Brown of Ladyton, a former Secretary of State for Defence, it provides the exemption for people who supported the armed forces overseas or who have otherwise been agents or allies of the UK overseas. Anyone seeking to rely on the exemption would need to provide notice to the Secretary of State within 1 week of arrival in the UK. Now, ministers have sought to reassure members that they were reviewing the position and that they would consider and revisit how the Illegal Migration Act and removal under existing immigration legislation will apply to those who are determined ARAP eligible. But I must note that responding in the House of Lords, the noble Lord Brown dubbed this assurance as worthless. And we should all be conscious of the strength of feeling amongst those former senior armed forces personnel who support this amendment. When individuals risk their lives to support British troops overseas, we must honour our commitment to providing sanctuary, not outsource it. And that is why I'm going to support the Lord's amendment.
Hear, hear.
Sir Robert Buckland.
Thank you, Madam Deputy Speaker. I'm mindful of time as always. It's quite rightly being reduced as we deal with this bill rather similar to some sort of exotic recipe where the sauce is reduced and reduced on every occasion. We're now down to two important amendments, and I'm glad that in his tone and in his approach to this, my right honourable learned friend on the dispatch box has absolutely embraced this debate as he should, which is all about the detail, getting it right. He knows that I support this policy. We've heard a lot of rhetoric again in this chamber which is unfortunate and misleading. We are doing something genuinely innovative, and it is right that we should do so. However, I do think that the revised Amendment 3G in its form now particularly in light of the remarks of my right honourable learned friend, the member for Kenilworth and Southern, does actually strike an appropriate balance here, not only in terms of making sure that the reality of the position in Rwanda is met by the deeming provision in law, but that there is a mechanism by which we can deal with this as a parliament if indeed circumstances change. And I think with great respect to my right honourable learned friend, he did almost concede that if there was to be a change in the situation in Rwanda, then primary legislation would have to be at least considered by the government. It seems to me, Madam Deputy Speaker, that it would be far better to ensure against that, to avoid the need for further primary legislation by making sure that in this bill we can wrap it all up and make sure that we have a system that is not just strong when it comes to potential legal challenge, but which also gives this place, I think, its rightful role. So I do, alongside my right honourable learned friend, still commend and support that particular provision. Now, I noted with regard to Amendment 10F, the comments that my right honourable learned friend made from the dispatch box, the assurances that he gave about the status of people who have had an assessment and are found therefore to have satisfied the requirements of the scheme. That's an important step forward. I don't take the view that we should regard these matters as worthless. I do regard it as having quite a lot of weight, and I'm grateful to him for that. I do think that making that very clear on the face of the bill would probably clear the matter up once and for all, and it may well mean, not that I mind being here till the wee small hours of the morning, Madam Deputy Speaker, but it may well mean that we can clear up this business once and for all. And I'm in the market for sorting this out now, so this bill can become law before it is too late this evening. That's why I would commend perhaps a little further movement on 10F by my right honourable friend.
Sammy Wilson.
Throughout this bill, my party, both here and in the other place, has given, by and large, support to the government, even though at times we've been sceptical and we have been concerned about how effective some of the measures are. But I've got to say, Madam Deputy Speaker, we draw the line when it comes to the Lord's Amendment 10F and the protection of people who have served with our armed forces in dangerous situations and now find their lives being put in jeopardy. And this amendment, I don't believe, the Minister has made the point time and time again that some of these amendments are wrecking amendments or attempts to create loopholes, etc. Let's look at the amendment. People who will be covered by this amendment, first of all, will have served this country. Secondly, as a result of that, their lives will be in danger. Thirdly, when they arrive in this country, they have within a week to immediately inform the authorities that they're here. And then that allows for their records to be looked at, for their claims to be verified, and for their connections with the armed forces to be ascertained. And lastly, if they haven't done that, then in any subsequent cases the courts can draw inference from it. So nothing can be more watertight than this particular amendment. And yet the government is refusing to accept it on the basis, well, there's already arrangements in place. Well, why is it, and my colleague from Strangford has raised time and time again in this House, and as of others, why is it that there are people who serve the armed forces in Afghanistan who find themselves in danger at present? They're on the run from the police in Pakistan. They're hiding because the police in Pakistan want to send them back to Afghanistan where they'll be in danger. Why? Because the system has not worked for them. And that's why I think it is important that this amendment is accepted. We have a moral duty. And as has been pointed out, if we're going to look to the future and recruit people in trouble spots to help the armed forces, then we have got a strategic duty. And I believe that if the Minister really wants to get this stuff through tonight, he's got a political reason for doing this. Because at least by accepting this amendment, he takes away another leg that the other House is seeking to stand on. when it comes to opposing this bill. And for all of those reasons, I hope that the Minister will accept this amendment to protect those who have served us, to get this bill through and to avoid any further delay.
John MacDonald.
Just to follow on from the member for East Antrim, we get to this stage I think this is a disgraceful bill. I want to oppose it at every opportunity, but you have to accept at some stage the bill will go through, and therefore it's the normal run of things in these matters that the government will compromise on a number of issues, and usually by this time. And for the life of me, I can't understand why we haven't reached that compromise so far, particularly on this particular amendment. I just want to make this particular point. It's exactly as member for East Antrim said, if the system was working as it was at the moment, we wouldn't be finding the cases that we've got. I think the situation in Afghanistan in particular is deteriorating at the moment. I just give one example of a case I'm dealing with. There's a woman who is in this country now who campaigned for women's rights in Afghanistan. The Taliban are now arresting and torturing her family. And that's just because she stood up for women's rights. If you're any way associated with the British government in any form, it makes matters even worse. I had another constituent in one of the hotels, an asylum seeker in one of the hotels, whose family simply rented out property to the BBC and some of the British authorities as well. The family got out, but they actually still had their connection with their video. They showed me the videos of the Taliban turning up and beating up almost to pulp the staff of that family who were working in those premises then. The situation is deteriorating. The existing system is not working. People who are in any way associated with the British government and the British forces in particular are targeted, and their family are targeted, and they're not just abused, they're actually tortured. I just think we have a debt of honour, and the compromise has to be done tonight. This amendment cannot be seen as a wrecking amendment in any way. It's simply a logical conclusion of the debate that we've had in both our houses. And I urge the other place to stand firm on this one, because I actually do think the British public support this amendment as well as this. But I actually do think maybe a majority in this House really want to support it too. So I urge the government to think again, because this has gone beyond the normal process. My honourable friend from the front bench said, what is there to gain from the government in continuing this process overall? If they think this is about demonstrating their own bravado, their commitment, trying to get some publicity out of this, I actually think it's going the other way. I think at the moment the general political mood and public mood is, for goodness sake, accept when there's a compromise offered, you should seize it, particularly on this particular issue.
Tim Farron.
Deputy Speaker, I hear from the other side impatience and irritation that we're still here, still debating this. I would respectfully just point to them the impatience, irritation, even outrage on the part of my constituents at the fact that this government is wasting vast amounts of their money on something they know, and the government knows, will not work. That there's a 1 in 200 chance that an asylum seeker might be sent to Rwanda is clearly not going to be a disincentive. What could be a deterrent would be to process the applications that we have and remove that 25% of asylum seekers who turn out not to be genuine. You will never know that if you don't have the competence to process it. What also would be sensible is to actually set out safe routes, so you are able to bypass and therefore undermine the model of the evil people traffickers. That outrage from my constituents also goes to the knowledge that what could be done with the money that has been spent on this nonsense scheme so far. It's the equivalent, Madam Deputy Speaker, of 5.7 million GP appointments if the government had the priorities that the British people wants them to have. These two amendments are entirely sensible. I don't need to repeat all the arguments for them, but that we should have independent verification and not simply declare that a place is safe despite the lack of evidence is nonsense. Of course, as an aside, if Rwanda is a safe place, then why would it be a deterrent? And if it's not a safe place, why would any decent government send anybody there? But I support the Lords in pushing 3G with 10F. I'm not going to give way because we're about to finish. It's unfair on others. 10F guarantees that those who've risked everything to protect and serve our men and women in Afghanistan, our servicemen and women, to not be betrayed by this or future government, is a basically simple and decent thing to ask for. And whatever the motivations the government ascribes to those those moving this amendment, it's clearly a totally reasonable one, and a reasonable government would accept it. But going back to finish the government's, to address the government's irritation, the Conservative Party's irritation that we are still here, I want to just gently encourage Conservative members here present, right honourable and honourable members, to imagine a time, sometime in the future maybe, when they are not in government and they are in opposition. Let's imagine a time when a government of a different colour ignores the rule of law, bypasses the courts, thinks itself above the law, and then tries to use its numbers in Parliament to steamroller through something that was not in their manifesto and for which they have no mandate. An honest answer to that question would lead to this government yield. This is awful legislation, it is cruel, it is inept, it is expensive. We should vote the amendments through, the law should keep going, the government should concede.
Minister Michael Tomlinson.
Madam Deputy Speaker, with leave of the House, may I address very directly my right honourable and learned friend, the member for Kenilworth and Southam, and my right honourable and learned friend, the member for South Swindon, because they have both addressed Amendment 3G. This amendment does not do what my right honourable and learned friends are looking for. They are looking for a parliamentary moment. This amendment merely produces a statement. And I would invite them to imagine a scenario whereby what we have been discussing would not produce a statement in any event, would not produce an urgent question, would not produce a moment for a Secretary of State to have a statement in the chamber of the House of Commons in any event. And I repeat to my right honourable friend, this amendment does not meet the challenge that he has set, and I would encourage him to be with the government in a few short minutes' time. Madam Deputy Speaker, we must get on and put an end to this. We must pass this legislation and to stop the boats. Perhaps in the words of my honourable friend, the member for Stone, I urge this House once again to send a clear and unambiguous message to the other place, and I beg to move.
The question is that this House disagrees with the Lords in their Amendment 3G. As mayors that opinion say aye. Aye. Of the contrary, no. No! Division, clear the lobby.